Everybody. This is Gil Cedillo. We are at the Ad Hoc Immigrant Affairs Committee for June 26, 2017. We're here in the main City Hall chambers, and I want to welcome each and every one of you. We have a full agenda today, and we'll try to move this as quick as we can. Last week was an incredible week, at least from my perspective. My career working on this issue. Last week, I think it was historic for us to put forth $2 million on behalf of the City of Los Angeles to defend immigrants, to make sure that they are afforded the protection of the law, and the commitment from the city. The Los Angeles Justice Fund, I think, was a significant milestone. But only one of many that have to be accomplished. This is a long struggle that we're in for, a tense pitch battle, and but I think it's important for us to acknowledge when we do make progress, as we did last week with the Justice Fund. And for those who are tuned in to the case of Romulo Aviles, the progress we made with his case and the dropping of the charges by the city attorney, which we wholeheartedly applaud. We've got a lot to do. Colleagues, yes, we can applaud that. Did somebody applaud? Thank you, Wayne. Colleagues, we're here. We've got a couple of public comment cards. Okay, so let's go. We're going to open up with public comment. Wayne, you want to come up and share your thoughts with us?
How many minutes, Mr. Chair?
Public comment?
3, Mr. Chair. 3. Is it on all items or just general?
3 minutes, you said?
Yes, sir. Okay. Is that good?
3 minutes, sir.
Okay. That's good. So, as you know, they were shutting down the Adelanto detention facility. And the reason what's going on in Adelanto, I was just out there with a client, they're holding people for years and years and years with no bond. I don't care what you ask for, they won't give you a bond. The judges won't give you a bond. They won't give you a bond. Every 6 months under Rodriguez, under a class action on Ninth Circuit, every immigrant is entitled to a custody review. The government is supposed to prove by clear and convincing evidence that a person is a flight risk and a danger to the community, which they can never prove. But for some reason, every time the judge says the government sustains its burden, no bond. So these people have kids. One of my people has 7 U.S. citizen children. A kid's going to turn 21 in January, and they don't want to give bond. And that's why people are angry. And the city attorney, as he reversed course, initially did not want to give relief to a 2-decade-old DUI conviction, and he's going to cause a father to be deported because he dropped his kid off to school, and ICE picked him up for dropping his kid off to school. Number one, schools are safe zones. So how can ICE violate a safe zone, arrest a parent of a child, and place a child's person and effects in danger because that child has no parent? Once school is over, the only parent is IHSS and Department of Social Services. So that ICE agent should be arrested by the LAPD in the city for violating a safe zone. I don't give a shit about federal law. That is child endangerment. You do not go into a safe zone and endanger a child's home for going to school. The Supreme Court has ruled illegal aliens have a right to an education. So how can a parent dropping off a child be arrested for dropping his kid off to school? It's completely illegal, and it's bull. And that's why this kind of crap's got to stop. Now, I noticed we had a big debate here Friday, and Councilwoman Nuri Martinez, who knows I'm going to be here today, is too scared to come in here today and face me. I got thrown out. I wanted to make a point. I have clients that do have convictions for sexual crimes, and they have green cards. And a lot of times what happens is the DA, the cops, they frame them, they put them up on trumped-up charges. I've gotten these people U.S. citizenship. I've gotten these people back their green cards because the law has changed where these convictions are no longer aggravated felonies. For the nerve of Nuri Martinez to take and throw me out for simply pointing out she's stupid and wrong. But fortunately, the city council and the chair particularly, you schooled her, and that's good. So I think that Nuri Martinez should stay off this committee. Nuri Martinez should no longer involve herself in the practice of law. And I just say one thing, I don't have a puppet with me. You do a good job, and I appreciate what you said on Friday.
Thank you. Other public comments are attached to items as we move forward. Colleagues, Mr. Rue, Mr. Price, any comments before we move forward?
None, Mr. Chairman. Just anxious to get on with our business.
Mr. Rue? No? Okay, so we're closing the open public comment period. We are now going to move forward. Mr. Clerk? Okay.
Item number 1 is a motion, Cedillo Huizar Martinez Price Wesson, requesting the city attorney with the assistance of the Bureau of Contract Administration to prepare an ordinance directing prospective and existing contractors with the City of Los Angeles to disclose under affidavit whether they have any contracts for design, construction, supply, procurement, or other development-related services regarding building any proposed border wall between Mexico and United States of America. This item is also referred to Budget and Finance Committee.
Okay. Colleagues, any comments? Motion to adopt, recommendation to adopt the motion and send to council for a report back.
That works, sir. Item number 2, motion Cedillo Price directing the Los Angeles Housing and Community Investment Department in consultation with the city attorney to prepare an anti-immigrant harassment ordinance that mirrors and expands upon the protections, enforcement mechanisms, and remedies listed in AB 291.
Colleagues? A recommendation to adopt the motion and send to council for a report back.
Very well, sir. Very well, sir. Thank you. Item number 3, a motion Huizar Cedillo requesting the city attorney to provide a legal opinion on President Trump's executive order to withhold eligibility for federal funding from those jurisdictions not complying with 8 U.S.C. 1373, and a legal opinion on whether the intent to withhold eligibility applies to all funding or just to those funds that have a nexus to immigration services. There's a request to make this a receive and file, sir, because the information is contained in another item on the agenda.
Yes, let's do that.
Okay. Item number 4. Number 4, or you would push to go into the 5 or 6?
No, 5.
5?
6.
6, okay. Item 6, City Administrative Officer report relative to the budgetary and operational implications of losing federal funds in the event of the Federal Administration's acts to remove funds from cities with policies that prohibit police action with the objective of discovering the legal status of a person and related matters. This item is also referred to Budget and Finance. We also have the CAO here to make a presentation.
Yes, can we get the CAO? Good afternoon, both of you.
Good afternoon, Yolanda Chavez with the CAO. I'm joined today by
Nick Campbell with the CAO's office.
Thank you. The report before you today responds to 3 motions related to 1, the federal resources the city receives, 2, the impact of losing any of these funds, and 3, the potential impact of the proposed federal budget for fiscal year 2018. We thought it made sense to merge these motions so that it would be easier to see what the city expects to receive this fiscal year, or expected to receive this fiscal year, and how the proposed fiscal year 2018 budget may affect these funds. The CEO conducted a funding exercise to estimate the amount of federal funding the city expected to receive this fiscal year by asking all of the city departments to provide this information. I want to note that the result of this exercise actually resulted in the expectation that the city would receive this fiscal year $1.6 billion. We also requested the same information from the Housing Authority of the City of Los Angeles, or HACLA, and the Los Angeles Homeless Services Authority. Although both of these agencies are not city departments, they both leverage resources with the city and provide critical services for housing and homeless services. So when we added the federal funding that both HACLA and LASA expected to receive this fiscal year, the 1.6 increases to $2.8 billion. As you know, these funds provide critical support for infrastructure, transportation, housing, community development, and public safety. And we estimate that it impacts about 418 full-time positions in terms of positions that are funded with federal funds. I think you're aware that on May 23rd, the Trump administration released its fiscal year 2018 budget proposal titled America First, a budget blueprint to make America great again, or proposed federal budget. This $1.15 trillion budget prioritizes public safety and proposes increases to the military, immigration enforcement, and veteran services. It is important to note that these increases are offset by more than $54 billion in reductions to other departments and to key anti-poverty programs, including housing, health care, and education. I do want to stress, though, that as it is a proposed budget, Congress has to consider this budget, and historically, Congress has not been able to agree on a budget resolution. If the budget is not in place by October 1st, Congress can pass a short-term budget bill or what is called a continuing resolution, or CR, to ensure that the government does not shut down. If they do this and pass a CR instead of a budget resolution, it is expected that the funding levels would remain at fiscal year 2017 funding. I also wanted to stress that since 1977, Congress has needed to pass a CR every year except for 4 to ensure that the government did not shut down. And actually, on several occasions, they had to shut down the government before they agreed on a CR. Attachment 1 of the report outlines all of the grants reported by the departments they expected to receive this year. I want to stress that it's not solely grants, but actually all federal funds, including reimbursements, one-time receipts, and a major portion of this money actually goes to infrastructure and capital projects. Attachment 1 also highlights all those programs that have been proposed for elimination by the Trump administration. So briefly, if you turn to page 4 of the report, we have a pie chart that outlines the federal funding by city service categories, major functions. As you can see, a big chunk of the federal money that we receive is used for street and highway transportation, infrastructure, as well as capital projects. In the proposed budget, the impact of the cuts really impact the other categories: environmental quality, human services, and other services, which include housing and community development. As the major departments that would take the hits in terms of federal government, in terms of federal departments, would include EPA and the Departments of Labor, Health and Human Services, Commerce, Housing, and Urban Development. In terms of city positions, it's important to note that about 780 city positions receive some type of federal funding to support those positions. That actually equates to about 418 full-time positions. 302 of those are civil service positions as reported by city departments. The most impacted departments overall in the city in terms of those that use federal funding to support their programs and positions include EWDD, Aging, Emergency, the Emergency Management Department, the Office of the Mayor, and HSID. So in general, those are the departments where the majority of their budget is coming from federal sources. Again, as illustrated in Attachment 1, the federal budget, the proposed federal budget targets a number of programs for elimination. And most of these that are targeted, such as CDBG, Home, as well as major cuts to the Workforce and Innovation Opportunity Act programs, would impact in particular HSID, EWD, and Aging, since they depend on these grants for programming and operations. On page 5, we give you an example of the impact to some of these services if we lost any of these federal resources in terms of the number of seniors that are served, whether it's meals, personal care, or employment, housing subsidies, and of course the financing of new affordable housing units. Of particular interest are the grants that we receive from the Department of Justice and the U.S. Department of Homeland Security. Although there's been a lot of discussion whether our federal funding would be cut based on the city's immigration policies, what is clear is that in this proposed budget, the administration intends to try to influence these immigration policies by recommending an amendment to Section 642 of the Illegal Immigration Reform Act and Immigrant Responsibility Act of 1996, or 8 U.S.C. 1373. These recommendations would, among other changes, condition grants and cooperative agreements awarded by DOJ and DHS to state and local jurisdictions to ensure that the recipients agree to send DHS information requested by the Secretary on related to nationality, citizenship, immigration status, removability, scheduled release date and time, home address, work address, or contact information of any individual in custody or suspected of a violation of law. It would also require grant recipients, such as the city, to exchange the above information with any other federal, state, and local government, law enforcement entity. And it would also force cities not to prohibit or restrict an official or employee from collecting, inquiring into, or verifying information related to nationality, citizenship, immigration status, removability, and again, scheduled release date, time, home address, work address, contact information of any individual in custody or suspected of violation of law. It would force grantees to comply with any lawful requests made by DHS pursuant to the Immigration and Nationality Act, including any request to maintain custody of the alien for a period not to exceed 48 hours in order to permit assumption of custody by Homeland Security. So if this amendment were to be approved by Congress, it would force the city to certify compliance in any application for funding and the resulting award agreements. Just to give you a sense of the funding the city expected from both DOJ and DHS, we do have an attachment that outlines that, but it's about $118 million. We go into capital programs, but the proposed budget does not propose any cuts to infrastructure, but we give you a sense of the projects that are funded with federal funds. In particular, the 6th Street Bridge in Boyle Heights, which receives major funding from the Highway Administration. In terms of HACLA and LASA, there are major cuts to public housing programs and rental assistance and minor reduction to federal homeless assistance grants. In addition, although the city is not a direct recipient, Medicaid would take a major hit, although a minor increase is proposed in this year, what would result by fiscal year 2020, and I believe the Senate bill that was just approved would change that to fiscal year 2027, would be to change the structure of Medicaid to a block grant. To give you a sense of the impact, what we would expect is that by 2027, spending would be reduced by 47 to 50%, but in California in particular, that would mean that at least 3.9 million Californians would be without insurance if those two bills related to the affordable, or what they call the American Health Care Act would be enacted, if it were to be enacted. In terms of filling the gap, we didn't provide a fiscal impact because, as you can see by the money we receive, it would be almost impossible to fill that gap of 1.6 billion or 118 million if it was just DOJ and DHS grants. So the city would either have to reduce these programs, cut these programs, or identify new sources of revenue. There are several revenue sources the city is considering, such as or working on implementing, such as the linkage fee, the cannabis tax, the billboard program, or any of those revenue sources, but those would be the options to the city. Unless any of these programs are actually eliminated, and depending on what happens with the federal budget, we would have to come back with a proposal for you. I'd like to turn it over to Nick Campbell now so he could very briefly review the attachments to the report.
Thank you. As Yolanda mentioned, I would go over the exercise that we went through with departments to gather this information. Our office released a memo earlier this year requesting departments to provide information on federal funding that they either received, expected to receive, or actively using. The actively using is mostly capital projects that are multi-year projects. They receive authorization for funding well in advance of when they start to draw down the funds. And this was meant to identify service impacts and the positions that were funded through federal funding sources within their departments. We sent out 2 forms that basically gathered information about individual grant sources, the federal department that the grant came from, as well as match requirements, pass-through elements. And this was meant so that we could have a comprehensive database of this information for future reference if we need future analysis in terms of potential other impacts or and changes to federal funding. In addition, I think the key part of this exercise were the estimates of the operational impacts to the departments. Not only do we ask them what positions might need to be reduced or be at risk should federal funding be removed, but also what metrics would look like, what these programs would look like if there were no federal funds. Could they continue? In some cases they could. In many cases they could not. And to give an idea of what that service level was, including on their metrics, so we can get an idea of what would be the baseline we'd be expecting were the worst case scenario to occur. And then this information was verified on a line-by-line basis in conjunction with department grant staff. In some cases was amended and modified, namely for grant programs that are, or federal funding programs that are not, say, standard, in the sense of grants are kind of the standard. Most of these funding sources are grants, but some things like capital programs are very different in how they're administered, and that leads to differences in terms of how we can analyze and present the impacts. I don't know if you have any questions on the exercise we underwent.
My questions are more in line for the city attorney.
Good afternoon. Valerie
Yes.
Flores, Senior Assistant City Attorney.
Yes, I'm happy to see you. My questions go more along the line of, I appreciate the exercise, but I think it's important for us not only to know what's possible, but to zero in on what's the probabilities, what's the case law, what are the instances where this has or has not happened, So if you could do that for us.
Yes, so in general, the federal government can change its priorities and eliminate programs, but in terms of conditioning compliance with, certain mandates in exchange for receiving funding, the Supreme Court has weighed in on a couple of important cases. One was a case entitled Dole, and another one was a case entitled Sebelius that involved the Affordable Care Act. The Supreme Court jurisprudence has developed a four-part test for determining whether conditions to federal funding are lawful. And the first requirement is that the conditions be clear and unambiguous so that the potential grant recipient can make an informed decision, sort of like deciding whether to agree to contract terms, in deciding whether to accept the grant in exchange for the conditions. The second criteria is that the conditions must have a nexus to the federal purpose of the funding. So the federal government would not lawfully be able to attach law enforcement conditions to housing funds or transportation funds. So there does need to be some relationship between the conditions and the purpose of the federal funds. Number three, the conditions themselves must be constitutional. They can't violate any principles or constitutional amendments. And lastly, the conditions need to be of such a degree in nature that they are incentives, but they are not so extreme that they constitute coercion. So for example, the Sebelius case, the court held that the condition that all Medicaid funding would be lost unless Medicaid was expanded was so onerous that it amounted to having a gun pointed to the head of the recipient, so that the Supreme Court struck that condition. In the Dole case, the condition amounted to about 5% of the program allocation, and the court seemed to find that that was an acceptable amount of incentive. It didn't quite amount to coercion. So where in between 100% and 5% the Supreme Court would land is tough to estimate. But those would be the four prongs: the clarity, the nexus, the constitutionality, and the degree of either incentive or coercion.
So, given that you've just laid out the criteria, how would you apply the criteria to what was just presented by the CAO's office?
Well, again, I think we'd have to look at each one on a case-by-case basis, and we'll definitely work with the CAO to do that if any of these materialize. But again, law enforcement grants can be conditioned on cooperation with immigration laws, and to the extent some of these are just across-the-board cuts or discretionary changes in priority, the four prongs wouldn't even apply. So we'd be happy to work with them and go case by case and report back.
Colleagues?
Thank you, Mr. Chair, and thank you for this report. Thank you for this very thorough report. So I just want to just make it clear. So as based on page 5, so the city attorney and the CAO are saying currently the situation as is, the city's federal funding is not at risk of being withheld under Executive Order 13768, right? Based on all of the past case law and all that, so we're protected. But just to answer all the reports, just in case, you just listed all of our federal funding, and it amounts to about $1.6 billion, or 2.8 if we add all the ancillary leveraging.
Right, that's correct. That's that's a request that was made in the motion,
Right.
that we outline all of the federal funding
And we're
the
just being
city
proactive,
receives.
right. Can you go over the 118 million? I missed that one little part. You said for 118 is,
Right, so as the city attorney stated, DOJ and DHS grants may be subject to limitations.
I'm sorry,
and-
what?
As the city attorney stated, DOJ and DHS grants may be, because they are related to law enforcement and public safety, they could be conditioned. So there's an amendment in the budget that would condition these grants to ensure you cooperate with immigration enforcement. And so the amount of the funding that the city received this year from those two departments was $118 million. And that's in attachment 3, the corrected attachment 3. And you could see where that funding, which departments received that funding.
And just to be clear, I'm sorry, just to be clear, currently the city is in compliance with 8 U.S.C. Section 1373. And so we do not believe any of our DOJ or DHS grants are at risk presently.
Okay. Attachment 3. Attachment 3, I have a grand total of 19 million.
Sorry, Councilmember, there was a revised version.
Oh,
The corrected version?
We can provide copies if you need them.
okay. I'll get that.
And just a note on on attachment 2 and 3, the position information, on attachment 3, that's what's fully funded, versus attachment 2 is what's anticipated to be impacted. Just as a note, as you're looking through those, the attachment 2 just shows what departments anticipate would be the positions that would be at risk, versus attachment 3 is just what's funded by those grants.
Okay. So now, based on this president, if he can he do anything for the funding to change, or our legal assessment to change where our funding would be jeopardized?
Well, only, it depends what happens with the budget, but as I said, his proposed budget eliminates many of these programs. It amends the Section 8 USC's 1373, or it proposes to amend that.
Right.
But again, Congress would have to agree, and historically,
So the budget process,
They
is the
don't
budget
have-
process, but I'm saying, can he have some sort of executive order where he somehow directly says, I want to withhold funding from Los Angeles? In
Right,
some
so-
legal justifiable way.
Right, we would definitely would have legal arguments to combat such an executive order, namely that it usurps Congress's spending power under the spending clause. So at present time, we don't anticipate that we're going to see such an order.
And I know our city attorney, Mike Fuhrer, gave us a very frank assessment and an update on everything that he's working on to protect the city of LA in closed session a couple of weeks ago. Can you, in open session, let us know, so what other avenues are we pursuing to make sure that we're proactive and keeps, so we're ahead of the curve and make sure that we're ready for anything that might happen?
Right, so I do have a presentation for you today on that, council members. Part of that can occur in open session, and part of it we'd like to have occur in closed
Okay.
session. So whenever you're ready, we can go ahead. And I'd like to call one of my colleagues up, Soraya Kelly, who works in our Public Safety General Counsel group.
Just, Councilmember, that's before the item number 4 on the agenda, and so this
Yeah,
is
are
still...
you ready? Okay, are you
So
ready?
I'll wait. I
Item
mean,
number
I'm done
6.
with my
How do
questioning.
you step here?
Mr. Chair.
I think we're next.
No questions at this time. Just kind of sobering to realize the impact that the president could have if he wanted to really mess with us, so to speak. Just keep us posted. Thank you.
Let's, can we get some public comment? David Aboot? And, Emmy McLean.
afternoon. My name is David Aboud. I'm an organizer with the National Day Labor Organizing Network. I'm here to ask, I know that there is a lot of concern that the City Council, that we may be losing funding for the City of Los Angeles, but I also want to say that the stakes are really high for us. Our communities are under attack right now. We have my personal friend, Claudia Rueda, was picked up by a joint raid between Customs and Border Patrol and the LA Sheriff's Department, which was opened, which the LAPD had prior notice of, and that was in Jose Huizar's district, Councilman Huizar's district. So I want to, urge you all to pass a stronger policy, pass an actual ordinance that is going to stop ICE from continuing to collaborate with our local law enforcement agencies and with local resources. And finally, I also have 4 community impact statements that have been passed by the neighborhood councils of Highland Park, Highland Park, Van Nuys, Palms, downtown LA, and Los Feliz, asking you all to do the same.
We'll share those with the clerk, please.
Where do I share them?
Hello, glad to be here. Emmy McLean from the National Day Labor Organizing Network. I would like to first recognize the important decision that was taken by the City Council on Friday to establish the LA Justice Fund, and this is the kind of bold and aggressive stances that the kind of bold and aggressive stance that the city needs, and that the City Council can and should take. We need protection of city funds, but as much we need you to protect the city residents. My colleague identified the CBP operation, which we're really concerned about, which resulted from initially an operation that was a joint operation between CBP and the LA Sheriff's Department, and led to initially the arrest of 1 woman as collateral, and then ultimately 7 more, with multiple people speedily being deported within 24 hours and children being threatened with being kidnapped if their parents did not turn them in for deportation. A man who's lived here for 30 years picked up on Figueroa Street in Highland Park after his name became known to ICE because of an LAPD arrest, and many others only in recent weeks. We've seen numerous, and I'm just coming to a close, independent academic and government legal experts who've advised that more can be done in LA, and we hope that this is the beginning of more being done. Thank you.
Thank you.
Sir, do you wish to note and file the CAO report?
Yes.
Okay.
Can we go to 5?
Item number 5. Sir, we have cards that came in on number 6. Can we...
Adam Bradlow, Adam and Emily Viano. Please join us. Adam.
Thank you, Mr. Chairman. My name is Adam Bradlow, and I'm a law student intern at the National Day Labor Organizing Network. I wanted to thank you, Mr. Chairman, and a number of the members on this committee for a very courageous and inspiring vote on Friday. With regards to item number 6, I wanted to note that, as I'm sure you're aware, the raid that appears to have targeted Ms. Rueda was conducted by Customs and Border Protection, CBP. And this is, to our knowledge, the first raid conducted by CBP within the community of Los Angeles, and really highlights the extent to which this committee needs to make sure that CBP and the federal government is not overstepping its statutory grounds for enforcing immigration laws in this community.
Please come up, Emily.
Hi, my name is Emily Villano. I am a law student at Yale Law School, but living here in Los Angeles. I just wanted to talk about how, as part of the sanctuary city policies that the City Council is considering, they should look to prosecutorial discretion as a priority. there's a growing awareness nationwide that we are over-prosecuting for low-level offenses that are diverting resources from things that the city really needs. And there are progressive stances being taken by other prosecutors' offices, for example, in Brooklyn, the DA's office in Santa Barbara, such that individuals are not caught up for misdemeanor offenses, small offenses like petty theft or trespassing or vandalism. And we know that the City Council can play a really big role in that because they've already done so with regard to street vending. That was a really big step forward for the city and has made a really positive impact. And the extent to which that they can continue to decriminalize and reduce the over-prosecution of the Los Angeles community would be a real asset to its sanctuary efforts. Thank you.
Thank you, Emily. We are item number 5.
Item number 5, continue from the March meeting, motion Martinez-Cedillo stipulating that all immigration consultants operating within the City of Los Angeles comply with all provisions of the California Immigration Consultant Act, as well as any additional locally tailored provisions that may be developed in order to maintain a valid business license within the city. The Chief Legislative Analyst, Office of Finance, and the City Attorney to report on the feasibility of developing a mandatory permit for immigration consultants, and the County of Los Angeles to report relative to the county's efforts to address immigrant consultant fraud. We have the CLA's office and the county representative here as well.
Thank you.
Good afternoon, council members. Before you is a report.
You want to identify yourself? For
my name is Henry Flatt with the Office of the Chief Legislative Analyst, and I'm flanked by Rigoberto Reyes, who's the Executive Director of the Office of Immigrant Affairs with the County of Los Angeles. Good afternoon. Before you is a report in response to a motion that was originally heard in this committee on March 30th, 2017. During that meeting, our office provided an oral status update regarding an immigration consultant licensing system and was instructed to report back on a framework for implementation and the resources necessary. Since the last meeting, our office has held meetings with the city attorney, council office staff, and County Department of Consumer and Business Affairs. We've also reviewed proposed legislation at the state, county, and federal level. The report before you is organized into 3 different sections. The first part is a description of the current County Department of Consumer and Business Affairs system of investigation, enforcement, and monitoring of notarios in the county, which includes Incorporated Los Angeles. The second section provides an update on the proposed legislation, AB 638, also known as the Immigration Fraud Prevention Act of 2017, which would provide that only licensed attorneys and federally accredited representatives would be authorized to charge fees relative to an immigration matter. This bill has been passed out of the Assembly and is currently in the Senate Judiciary Committee, where it has just been amended on Friday. The third section provides recommendations and possible solutions the county may use to mitigate the ongoing problem of immigration consultant fraud through a coordinated outreach and education marketing campaign. Specifically, the 4 recommendations consist of the following. Recommendation number 1, instruct the CLA with the assistance of the CAO and city attorney to continue to meet with the county relative to an immigration consultant fraud system and prepare a draft memorandum of understanding and the necessary ordinances between the city and the county DCBA, Department of Consumer and Business Affairs, delineating the provisions necessary to expand the county's investigative and enforcement efforts combating immigration consultant fraud in the city. Number 2, instruct the CAO with the assistance of the CLA to work with the county to develop a potential cost estimate for dedicating county resources related to immigration consultant fraud in the city. Number 3, instruct the CLA to continue to monitor AB 638 and report on its implementation and impact on the final city immigration fraud program. And lastly, instruct the CLA to establish a working group consisting of relevant departments and stakeholders that includes the development of a marketing campaign in various languages that consisting of a pamphlet, website, and hotline to raise awareness about immigration consultant fraud and provide a mechanism for tracking and reporting such incidents. I'm here to answer any questions that the committee members may have, along with Rigo.
Sir.
Thank you. Thank you very much. Rigoberto Reyes with the Office of Immigrant Affairs in the Department of Consumer and Business Affairs with the County of Los Angeles. As Mr. Flatt mentioned, as instructed by the County Board of Supervisors back in September of 2016, last year, our department, the Treasury Tax Collector, County Council, and the District Attorney's Office set out to review existing protections for consumers as it concerns immigration consultants, notarios, paralegals. Out of concern, we had, through experience through the department and just reports and issues we were seeing, basically to enhance existing consumer protections for consumers in the County of Los Angeles. And basically, after a good 4 months of continuous work, we came out with a proposed two ordinances at the county level. One, to license immigration consultants that we defined as immigration assistance providers, a license that would be issued to the provider as well as the proprietor to ensure that they were both covered. It's a very strong licensing proposal. And then on the consumer protection side, we also came up with a separate ordinance to enhance the protections the Immigration Consultants Act provides already. Both ordinances were submitted to the board, and they are now reviewing them. They are also waiting to see the outcome of AB 638, which would impact the proposals we made. So, as Henry mentioned, if you have, the council has any questions, we would be more than happy to answer them and expand upon our report.
Colleagues? No, we're good. Okay, let's move to adopt and send to council. Does that work?
Will do so.
Thank you so much. Okay, item number 4, back to 4. Okay, item number 4.
Item 4, City Attorney reports relative to challenging the legality of the federal government requirements for the city to check immigration status for recipients of existing and future city program services, to report relative to recommendations for undertaking a more proactive, aggressive strategy to counter federal immigration policies harmful to city residents, and the Los Angeles Police Department to present a verbal report relative to the department's review of the LAPD manual to ensure consistency of current practices and recommendations for revisions of Special Order 40. The committee can move into closed session to confer with its legal counsel relative to the above matter regarding initiation of litigation pursuant to paragraph 4 of subdivision D of section 54956.9.
Can we public comment before we go in?
Yes. Probably should do public comment first.
Yes.
And so the representatives from the city attorney's office also have an open session report, just to give you some
Yeah,
additional
I wanted
information.
to bifurcate those if you want to do that,
Okay.
but I was thinking we'd go to public comment first and then bifurcate the public comment or the public report and then go into closed session. All those on public comment on item number 4 before we go into closed session. Emily Villano. Did she leave? I'll hold her card. Adrian Butler. Emmy McLean. I saw her walk out. And Joseph Viela, please. Yes, sir.
Good afternoon. My name is Adrian Butler. I'm a current UCLA law student and a concerned community member, and I'm here to speak on the current LAPD misdemeanor arrest policy. While it's a great thing that the city has policies in place to not actively cooperate with federal immigration authorities, the current misdemeanor arrest policy leads to the arrest of many immigrants for low-level petty crimes that don't pose a real severe threat to public safety. Even without direct cooperation with federal immigration authorities, These arrests and detentions put immigrants and their families at risk because the arrestees' fingerprints and other identifying information is automatically shared with federal law enforcement, including DHS and ICE. And this can lead to increases in immigration detention and deportation. Other jurisdictions have taken really broad steps to limit these types of interactions by working to decriminalize these offenses, and it's important that the City of Los Angeles take the lead in changing their policies to reflect the goals of protecting community members from aggressive immigration enforcement.
Thank you. Victor Nato, please. UCLA Labor Center. Anthony Ng, Asian Americans Advancing Justice, and Nina Torres.
Good afternoon. My name is Victor Nato with the UCLA Labor Center. I first want to commend the City Council, especially Councilmember Cedillo, for the leadership on Friday. I felt we created momentum, and now with momentum, we got to go deeper with some of the more serious issues facing us today. The reality is that federal agents are in the city jurisdiction every day, and they are involved in different kinds of task force. They are involved in different kind of criminal enforcement. And so we have to accept the reality that with the presence of federal agents, this administration, we do have a crisis that we need to deal with. And I think this is why it's more important than ever before that we got momentum on Friday. We need to move forward with some good steps to create a policy in Los Angeles that's going to protect immigrants. Thank you so much.
Good afternoon, members. My name is Anthony Nong with Asian Americans Advancing Justice LA. I'm here to thank the City Council for its bold efforts to ensure that everyone is represented through the LA Justice Fund, and really to continue that momentum in protecting all of our residents by, one, ensuring that the Executive Directive 20 is put into ordinance as well, right? I think it's a great step that the mayor put those policies up, but I think we really need to ensure that those are made into ordinance. As well as kind of following the lead of about 70 organizations who sent a letter to the mayor in February 10, 2017, of outlining what a sanctuary jurisdiction would look like for Los Angeles residents, and really echoing the fact that we need to continue this bold leadership to ensure that all of our residents feel protected. As someone that's undocumented, I really do appreciate the effort of the City Council in ensuring that I feel welcomed here in Los Angeles. Thank you.
Thank you.
Good afternoon. My name is Nina Torres, and I'm the Program Associate from National Immigration Law Center. The National Immigration Law Center is dedicated to defending and advancing the rights of low-income immigrants. Within the current political climate and administration, the immigrant community is directly being attacked. LA City Council has yet to respond correspondingly to strong policies to protect the residents from aggressive immigration enforcement and to ensure that LA is not complicit in deportations. Therefore, it is important for LA to be a leader in this fight and help its residents. To further protect and serve LA's diverse community, we must ensure that policies established by Executive Directive 20 are enshrined in an ordinance endorsed by the City Council and are meaningfully implemented and enforced. Thank you.
Thank you. Carlos Amador. Amy.
I think I was called a moment ago while I was outside. Someone
Sure.
had mentioned. Okay. Hello again. I've represented and have met with numerous people who have been arrested as a result of LAPD actions only to find themselves in immigration detention, in deportation proceedings, and in numerous cases on the other side of the big, beautiful wall that already exists on this country's southern border. I'm also honored to walk alongside a young activist who only recently, in recent weeks, found herself handcuffed in the back of a police car only as a result of her stepping in off the street to defend a family, an immigrant family that was facing harassment from passersby. It's not true that LAPD is doing all that it can and that the current policy is protective of immigrant populations. I'm part of a broad coalition that has been engaging with LAPD over the course of more than a year before the election to try to establish better policies. We need the City Council, we need the police commissioners to step in too and ensure that our policies represent the values of this city, which they don't currently do. And I have some documents to share with you. I think most of you have received them already, but I will share them again.
Thank you. Carlos, Joseph.
Hi, good afternoon, everyone. Carlos Amador with the California Immigrant Policy Center, and this is Viviana. Went to pick her up from daycare. And first of all, thank you for your leadership, Councilmember Cedillo. We're excited to see the LA Justice Fund passing on Friday. I'm really looking forward to working with all of you and making sure that it is an inclusive program for everyone here in the city and the county. I really wanted to highlight the importance of continuing to move forward on having strong sanctuary policies that should be implemented here in the city. I concur with folks that have spoken that the policies that are in place don't go far enough to make sure that the residents here in the city, which I am one of, are protected from all of the federal anti-immigrant attacks that are coming our way. So I really urge you to make sure that the Executive Directive 20 that was announced a few months back is fully implemented and the policies are fully laid out in city as part of city ordinance. Thank you.
Did Joseph leave? Scott Doyle? And Mylene Carberry or Cranberry? Carberry?
Good afternoon. Building on the momentum of the LA Justice Fund victory, we feel that the next step is clearly a sanctuary ordinance that works to disentangle local law enforcement and federal immigration enforcement. Mayor Garcetti and Chief Beck frequently say that the LAPD do not and will not assist federal immigration authorities. That is simply not true, or at best only half true. Special Order 40 only prohibits LAPD from engaging in activities whose primary purpose is immigration enforcement. This allows for a range of joint activity and communication where, however indirectly, LAPD does in fact aid and abet federal immigration agents. Yet we can't begin to address this cooperation until we know the full extent of it. So I'd encourage you to ask that the LAPD comply with the Public Records Act request made in April by UCLA law faculty and immigrant rights organizations. If we to ensure that local law enforcement doesn't unwittingly play into the hands of Trump's deportation machine, we must have full transparency. And I have a packet with that PRA request, among other things.
Thank you, Scott. Eileen and then David, or Daniel Abu.
Hi, my name is Milen Carberry, and I am a constituent, and I'm a first generation American. My parents were immigrants from Canada. My mom was Indigenous, and my father French-Canadian. The reason I'm here is that I just feel like we grew up believing that this country was sanctuary for people that wanted to get away from hardship and wanted to provide for their families. And now I feel that whenever we look around, our country is a detriment, like it's a scary place for immigrants. It's no longer a safe sanctuary. And I was so proud when Mayor Garcetti took the directives, the directives on, but I'm just hoping that we move forward and bring it into an ordinance. Because we're still not safe. Though we have the photo opportunity to look like a sanctuary city, we're still not protecting. And I know that you guys know this, but I'm just saying as a constituent, I really would love to know that my neighbors are safe and that families are kept together and that we care and that we mean what we say. So thank you so much.
Thank you. David? Daniel? David?
David, yeah, David, thank you.
Good luck in medical school, too.
Thanks. So again, my name is David. I also want to applaud the actions of the council on Friday in passing an inclusive LA Justice Fund. I think that, again, we can also build on that momentum to create stronger sanctuary policies that will stop that disentanglement. So I wanted to read a little bit from the community impact statements that I just submitted that are in Councilmember Ruiz, Councilmember Cedillo's, Councilmember Huizar, and Martinez's districts. So just some quick bullet points of what they say. Declare Los Angeles a sanctuary city, following the examples of Santa Ana, California. Develop an ordinance to ensure that Mayor Garcetti's Executive Directive 20 is properly enforced. Address vulnerabilities in Mayor Garcetti's Executive Directive 20. Ensure that undocumented immigrants facing deportation remain entitled to legal representation and due process of the law without exception, and ensure that people of color are not subject to increased policing or profiling. Although not everyone could be there today, these community impact statements represent hundreds of thousands of your constituents, and I hope that you will follow their lead in creating these ordinances. Thank you.
Thank you. And then finally, Justine Amado.
Hi, good afternoon. I'm a veteran of the United States Armed Forces. My background also, I have a degree in Homeland Security with minors in Terrorism Studies and International Relations. I also work for the Center for Human Rights and Constitutional Law. In regards to Executive Order 20 and also SP 40 and also SB 54, I've read through all of them, and none of them protect immigrants directly. They all contradict exactly everything when it comes to regards and information protection. You want to protect the immigrants of Los Angeles, protect their information. They shouldn't be asked on the street what your place, give me your place of birth. How are you protecting immigrants? You guys are sitting here wanting to protect immigrants? Stop it. Protect their information. Find a way so that their information is protected on the systems that the FBI uses with also local law enforcement. The distribution of the networks within each other. That's how you protect people. And that's how you're going to start protecting them here in the city of Los Angeles and nationwide.
Thank you, Justine. Okay. Can we get LAPD up here? And
Good afternoon, council members. My name is Arif Ali Khan. I am the Director of Constitutional Policing and Policy for the Los Angeles Police Department. Seated with me is Captain Al Labrada. Captain Labrada is from our Hollenbeck area and is also one of the immigration liaisons, especially with the Latino community in Los Angeles. On behalf of Chief Beck, I want to thank the committee for inviting us to come and present about the LAPD and its role in immigration. Immigration, especially the legal aspects of immigration, is a very confusing area of the law, and because of that confusion, there's been quite a bit of uncertainty about the LAPD's role in immigration enforcement and its current policies, procedures, and of course the law that is changing as a result of many of the issues that have come forward. It has further created the current rhetoric that's coming out of Washington, and of course the debate about immigration has created a lot of uncertainty. So the opportunity to come here today to talk about what the LAPD does and does not do is very much appreciated. Before I begin, I just want to mention that since our last appearance before the committee, the LAPD issued these frequently asked questions on federal immigration enforcement and the LAPD's role. We have copies of these for the council members. This is available to the public in both English and Spanish on the lapdonline.org website. What I thought I would do today is talk a little bit about LAPD's responsibilities and do it in 3 different scenarios and explain what our current policies are, and then also what we are looking at in terms of trying to update and clarify some of the policies and procedures that exist in the LAPD Department Manual and other documents. I do want to say, however, that as an immigrant myself, and as somebody who comes from a family of immigrants, who works in a department with many immigrants, in a city, a state, and a country of immigrants, this is a very important human issue for the LAPD. It's something that means something to every officer who interacts with the many Angelinos here and sees the impact that the current debate has had in a very palpable way. Captain Labrada will talk a little bit about that when I give the overview, and especially the importance of the community outreach that we've been doing for many, many years, but obviously quite a bit more in recent times. What's often confused in the issue of immigration enforcement is the distinction between civil immigration enforcement and criminal immigration enforcement. Because of the word illegal immigrant, which is often used, there's an assumption that somebody who's an illegal immigrant is committing a crime. And that is not the case. A person's immigration status is a civil administrative status of whether somebody is in the United States legally or illegally, but it is not a crime in and of itself to not have immigration status. A person can lose their immigration status for a variety of reasons. That could be treaty obligations, it could be they overextended their visa, and of course it's because they could be because they entered the United States without the appropriate paperwork. But somebody who is undocumented in and of itself is not committing a crime. There are criminal provisions and criminal immigration enforcement, and I should add, I have a lot of experience with these issues. I served as a federal prosecutor here in Los Angeles for 10 years. I prosecuted serious federal criminal immigration violations as well as cases where people were exploited because of their immigrant status and were smuggled or extorted. And I also served as an Assistant Secretary of Policy Development at the Department of Homeland Security, so I'm very familiar with many of the laws and issues that come to this. But on the criminal side, there are federal criminal violations that involve immigration. The two biggest ones that exist that relate to somebody entering the United States without authorization is Title 8 U.S.C. Section 1325, known as improper entry into the United States. And that is if somebody comes through a port of entry and doesn't have permission to do so. What's important about that crime, though, is it is a misdemeanor. It is a misdemeanor, meaning it can only be punished up to a year in federal prison. And as a misdemeanor, the crime is completed upon entry. So if somebody were to come across the border at San Ysidro and enter, the crime is committed and completed once they enter. That is important because if somebody enters the United States that way, it would be a crime. However, a police officer, a Los Angeles police officer, would not be able to arrest that person simply because they're here in the United States in violation of that code. Because California law, as in most states, does not allow a police officer to arrest somebody for a misdemeanor that does not occur in his or her presence. The LAPD has long had a policy of not arresting people for Section 13825. That was adopted in Special Order 40 back in 1979 because there is no legal authority to do so. Also in Special Order 40 is that a police officer in Los Angeles cannot stop somebody with the objective of trying to determine their immigration status. The reason for that is, at the time, and they still exist today, the LAPD does not engage in civil immigration enforcement. And also, if it did, it would be very difficult for us to maintain the trust that we need with the community to deal with the many issues in the city of Los Angeles with respect to crime. That was recognized in 1979 by Chief Darrell Gates, and it's even more true today. Also, because immigration status is not a crime in and of itself, a police officer cannot stop somebody because they're suspected of being in the country illegally. And that was upheld by the U.S. Supreme Court in 2012, which said that immigration status is a civil violation. So the two elements of Special Order 40 that was adopted by the Police Commission back in 1979 are that you cannot stop somebody because of their immigration status, and you cannot arrest them under Title 8, 1325. It is the law of the land even today. So some critics say that it provides some sort of special sanctuary or things like that. The LAPD's principle then, and as it is now, is that we protect the public consistent with the law, and Special Order 40 is consistent with the law. Now, since that time, there have been many other things that have come out with respect to criminal enforcement, civil enforcement that the LAPD has adopted, in particular detainers, and I'll talk about that in a second, whether we ask somebody about their immigration status, whether we keep records of it, and in those circumstances where it's appropriate to do so. But before I get to that, I just want to mention one other federal crime that's important, and that is 8 U.S.C. Section 1326, not 1325, and that is illegal reentry. And that is a federal crime where somebody has entered the United States improperly, was convicted of a crime, or not convicted of a crime, is removed, still does not have permission to come back into the United States, but does so. That is a felony under federal law. And in some circumstances, the LAPD will detain and transfer that person to federal custody because of that federal crime, not because of their status civilly, but because of a federal crime that may have been committed. Now, in any case, whether it's 1325 or 1326, if there is somebody who has a warrant for their arrest issued by a federal judge for the crime, the LAPD will arrest somebody for that criminal offense. But the biggest difference is whether it's a civil immigration effort or a criminal immigration effort. The LAPD, as a law enforcement agency that focuses on crimes, would only take action when there is an actual crime. So to bring this more in context, I think it would be helpful to look at it as the three situations in which the LAPD may come across somebody who is undocumented and what the policies and procedures are applied. The first would be an encounter in the field. The second would be when we have somebody in LAPD custody. And the third would be where and when does the LAPD participate in a task force in which there is participation by Immigration and Customs Enforcement, or they're actually the lead agency in that task force. So in the field, if a patrol officer or some other investigation, as I mentioned, could not stop, and it's not legal to stop somebody based on their immigration status, but they could end up coming in contact with somebody who's undocumented. But we do not ask if the immigration status, because it's not relevant to any of the crimes that we would be looking at. However, if we were to come across somebody, we were to get their identity, run them through various databases, and they came back as somebody who was wanted for a federal crime because there was a warrant for their arrest for an immigration crime, just as any other federal criminal action or warrant, we would make an arrest. They would be arrested on that, transferred to federal custody, and then be required to make an appearance in front of a federal judge, just as if they had a federal warrant for bank robbery or securities fraud or something else. And in certain circumstances, there are circumstances where if we become aware that somebody was previously deported, was convicted of what's known as an aggravated felony that's defined by federal law, and we can verify that, we will detain them and contact ICE to determine whether they would take them into custody for prosecution for that offense. But it's a very specific circumstance where it's somebody who is convicted of a very serious felony where we would do that, and there's a whole level of review that's required, and that's more fully explained in the FAQs, so I'll leave it to that. The second situation would be you arrest somebody who's in LAPD custody and they're undocumented. Now, as I mentioned, we generally would not know if somebody's undocumented because it's not typically, unless there's some very, very specific reason, we would not ask, and we wouldn't know. We do not notify ICE that somebody is undocumented, nor do we maintain records of a documentation status of an individual unless it's relevant to the particular case. So, for example, if somebody was a victim and they were victimized because of their immigration status, there will be some record of that in a report or something else. And I should mention the situation in dealing with somebody who's a suspect of a crime or the victim of a crime or a witness to a crime applies equally. The issue of immigration status is not relevant to the enforcement actions that the LAPD has taken, and it's not a question that we would ask or something where we would notify ICE if somebody was undocumented. So notification and records. But how does ICE know that we have somebody in our custody who's undocumented? When somebody is arrested for any offense, whether it's misdemeanor or felony, they are fingerprinted. And they're fingerprinted, and those fingerprints are sent to the FBI at the U.S. Department of Justice. And we do that to find out, is this the person who we think it is? Also, are there any other warrants out there for the person's arrest? What's their prior criminal history? The Department of Justice and the U.S. Department of Homeland Security have an information sharing agreement. And DHS will be notified if somebody's in our custody, and then they run it through their databases to determine whether it's somebody who was previously deported or somebody who is undocumented and possibly subject to removal. They will then send over to us, depending on the circumstances, what's known as a detainer. An immigration detainer notice of action. It's changed names recently. What is a detainer? A detainer is a request for a local law enforcement agency that has somebody in custody that says, hold on to this person beyond the time in which you are legally supposed to, and we'll come pick them up within 48 hours. It is not a judicial warrant. It's not a warrant for somebody's arrest. It wasn't issued by a judge, and it's not alleging that the person committed a crime. It's about removal and deportation proceedings, and as I mentioned, is a civil process. Also, it is not supported by probable cause of a crime. And under the Constitution and the Fourth Amendment, we cannot hold somebody in custody if we do not have that probable cause determination. So, for example, if somebody's arrested and they're in our custody, and by law they can post bail, we cannot hold them beyond the time in which they post bail based on an immigration detainer. It has to be a warrant, and we've insisted on warrants in order to hold somebody in custody. There are court decisions that have come to that effect. This is the advice from the city attorney's office since 2014, and I'm sure the city attorney's office can get in more detail about that. There are other circuit courts throughout the United States that have come to that same conclusion. And despite requests of the federal government to tell us if there's some legal basis to hold somebody without probable cause and not violate the Fourth Amendment, that has never been brought forward. Do we allow ICE or to come in and interview somebody who's in our custody? As with any law enforcement agency, we do allow an interview of somebody, but under California law, under the Truth Act, it has to be with the consent of the person to be interviewed. So if an ICE agent wanted to interview somebody at one of the jails, that person would be advised that ICE is there, and if they consent to it, we would allow it. But they are not present in the jail, and they are not allowed to just routinely ask people who are in custody to be interviewed. And then finally, we do not hold on to suspects for very long, because our jail is for booking and then transfers to the LA County Jail, or it could be another county jail for appearances in court. So unlike the issues that the LA County Sheriff and other counties have, our custodial circumstances are very different, and that's why some of the issues that the LAPD is concerned about with respect to immigration are very different than, let's say, Sheriff McDonnell has with respect to holding people for much longer and issues of working with ICE. The other thing is that I mentioned that as a local law enforcement agent, we do not enforce civil immigration law. There is one provision in federal law that actually enables a local law enforcement agency to do some immigration enforcement, and that's known as a 287G agreement. You'll hear about that quite a bit in the discussion. A 287G agreement is a specific agreement with the federal government to take on the additional responsibility of certain civil immigration enforcement actions. The LAPD does not have that agreement. We would never expect it to, and it is now specifically prohibited through the Mayor's Executive Directive 20 to have that type of agreement. And so, as of last count, there are only about 30 to 40 agencies in the entire United States that have that type of agreement, and it typically is by a sheriff's department that has it purely for the custodial circumstances. And so with the last, just very quickly, I'll talk about the last circumstances, which are task forces with the federal government, and in particular ICE. Immigration and Customs Enforcement was formed after 9/11 and the creation of the Department of Homeland Security, merging various functions into one agency. All the immigration functions that previously was part of the Immigration Naturalization Service in terms of the actual enforcement issues, and then the customs from U.S. Customs, which includes narcotics enforcement, intellectual property, crimes against children, certain border crimes, and identity theft, and human trafficking. The LAPD participates on task forces, some that are led by ICE and some that have ICE participation, but only with respect to things that do not involve civil immigration enforcement. The LAPD has, in our Memorandum of Understanding, in those task forces, specific language that we will not engage in civil immigration enforcement. We do not allow any deputization of officers to do immigration enforcement, and we make it very specific that any LAPD officer who's a participant in a task force must comply with LAPD policies and obviously city law, etc., in doing so. Many of these task forces are very important. They go after very serious crimes, especially those involving the exploitation of children, and we do everything possible to make sure that if ICE collaterally does anything in their jurisdiction that is not part of a task force operation, and we will not participate in that. I should also mention the Joint Terrorism Task Force is another major task force in which ICE participates, and as do we. SB 54, which is the bill sponsored by Senate Pro Tem De Leon. As you may know, last week Chief Beck appeared with the senator to express his support for that bill, something that the City Council has already done, as has the mayor. We were able to work very closely with his staff and many of the advocacy groups to make sure that the provisions of that law essentially allow us to do what we've been doing over the course of 40 years, which is not be required to do civil immigration enforcement, and where appropriate to participate in criminal immigration enforcement as needed. But just to conclude with this, I just want to mention that our goal is public safety, and it's protecting the public consistent with the law. All of the policies and procedures, all of the issues that I've mentioned are consistent with the Constitution and state law. And although there's a lot of uncertainty externally, I can assure you on behalf of Chief Beck, there is certainty by the Chief that the LAPD is not changing its proven crime-fighting strategies, which is about reliance and community trust, and because the participation and assistance of all members of the community, regardless of immigration status, is so critical to protect the community. And one last thing in terms of what we are looking at in terms of updating, and I know the specific provision in the agenda is about Special Order 40. Special Order 40 is something that's existed for quite some time, but it's really about the principles in Special Order 40 that are codified in a variety of things. The fact that we don't ask about immigration status, we do not stop people based on their immigration status, and we do not enforce the federal law provision that we're not allowed to. But there are many other things that I mentioned, detainers, and how we deal with information, et cetera, that have nothing to do with Special Order 40. Those are all in various documents as part of the LAPD bureaucracy. What we are doing right now is we are trying to go through all of that and to update the language. In some of our documents, it refers to aliens, as the federal law does, and updating that, and also making it very clear to the officers and the community what it is we do and don't do. The frequently asked questions was one way to communicate that, and this is something that has helped the officers quite a bit, but we are doing that review. We are also working with many of the advocacy groups, both here and in Sacramento, to talk about some of the recommendations they have. In many ways, we have to maintain a balance between not enforcing civil immigration law, but also we do not shield the enforcement of criminal laws against anybody, and how we have to maintain that balance and focus on protection of the public consistent with the law. So with that, if I could just turn it over to Captain Labrada, and he can mention a little bit about what LAPD is doing on the community partnerships.
Good afternoon. Captain Al Labrada with Hollenbeck area. I've had the opportunity for the last 4 years plus served as one of the advocates for the department for the not only undocumented communities, but more importantly, the Spanish-speaking communities. The last 4 years, we've been working with a lot of groups in support of AB 60, in support of changes with Special Order 7, our ICE detainer policies, and most recently with their advocate groups regarding the changes to Special Order 40 and bias policing. I'd like to say that some of the efforts also reached out to our local Latin American consulates that we have here in California and the LA area. It's important to work with them, but more importantly with our Spanish media. One of the things we implemented shortly after the post-election was the outreach with the community. We've had over 150 meetings within the community to address not only the fear, the trust issues that have been caused as a result of post-election, and more importantly, to ensure the community that our stance on immigration has not changed. We're working with our community advocate groups. We have a meeting coming up in July 10th to continue to receive input as we did with other policy changes, as I mentioned before, but more importantly, to educate based on what we're learning from the community, our command staff. Recently, with the release of the FAQs, we pushed that out to every command staff officer within the LAPD. That has been also put in the lands in English and Spanish, but more importantly, we ensure that our captains are getting that information and pushing that out with the respective 21 divisions here within the city to ensure that they're getting the accurate information to push out to the community. More importantly, the importance of trust is built on 2 locations for us. And what we're working on recently is the outreach at the schools, at the elementary and middle schools. It's important for us to get to those parents. One of the things we're doing in preparation for return to school in August is reaching out to those parent-teacher groups to come out and discuss those FAQs and talk about the continued trust building and the importance of reporting crimes. The issue of reporting crimes is a significant concern for us, and we continue to remind the community that victimization is not only to U.S. citizens, but to everybody that lives in this community. And that's one of the focus of our challenges that we push out consistently. Most recently, the work with our clergy council, reaching out to the Catholic churches and the Archdiocese, working with them, the Catholic churches, and going to those Sunday masses. I've had the opportunity on many occasions, as well as Chief Arcos, to attend some of those masses and speak on our stance to ensure the community is well aware that our stance has not changed in supporting them here in the community. As an undocumented resident myself, I understand a lot of the fears. I was undocumented for many years, immigrant from Mexico, and I understand a lot of those fears. And I think it helps us in the department learn from those fears and get back that information to the communities. So we'll continue to do that. And more importantly, the information coming from our advocates, we need to push that out to our command staff to make sure we do that. On a daily and weekly basis, Chief Arcos and I are getting concerns and calls from advocates or just residents within the community of concerns, rumors within the community of raids and other operations within the city. And it's our job, and we continue to do so, working with ICE and Dave Marin at the ICE office here locally to address and dispel a lot of those rumors. And I think it helps in the trust building. We'll continue to do that and continue to reach out to our churches, our local elementary schools, and continue to work with the advocate groups in pushing out that message to build trust. Thank you.
And Captain Labrada reminded me of the issue of raids by ICE and other federal agencies. The LAPD does not participate in immigration enforcement raids with ICE. We do not provide security. We do not participate on any task forces in which that's the purpose of doing it. We will be notified that there may be an enforcement action. But we do not, and the reason for that is we need to know what's happening and where it's happening in the event that there is an emergency so that we know what we would be responding to. But we do not participate or provide perimeter security or any of those issues for immigration raids in the city of Los Angeles.
Colleagues? Mr. Rue?
I just want to say thank you. I mean, I have to go, but I just wanted to say thank you, and it's great that I'm an immigrant, and the fact that the folks who are actually working on this policy are immigrants as well. Only thing I ask is if you could continue to push out the information out there, because there's a lot of misinformation and there's a lot of confusion. So I know you're already doing it, but the more you could share what we're doing and exactly what it is that we're doing. Thank you.
Thank you.
Mr. Price?
Yes, thank you for the report. Good overview. I got a question about item 11. Does the LAPD notify ICE if a suspect or arrestee has an immigration-related criminal arrest warrant? And we say yes. If the LAPD police officer learns that an arrestee has an outstanding arrest warrant, the police will notify ICE or the originating agency to determine whether or not the agency will take custody. In those cases, when they don't take custody, what happens? They just kind of let it go, or it's not a big deal, or what do you think?
It would be just like in any other case. There are times when somebody may be stopped and they have a warrant that could be out of another county or it could be a federal warrant. We will always try to contact that originating agency to see if they will take custody, because it doesn't make sense to arrest somebody, put them in our jail, and then just release them. If ICE does not, now that could happen either in the field, it could potentially happen at the police station, and if there's no other cause to hold them, they would be released.
After 5 hours, 10 hours, a day?
The law requires it to be within a reasonable period of time. If they're arrested on a warrant, technically we can, if there's already been a warrant issued for the person's arrest, there's already been a finding of probable cause by a judge. So they are entitled to go before a judge within 48 hours. But if it is a warrant issued by another agency in another area, we would contact them, and if they said, no, we're not going to pick them up, then we would release them soon after.
Does that happen frequently? It happens sometimes? Does it happen? In your experience.
So I don't think it happens frequently with ICE in terms of their, having criminal warrants, but it does happen frequently with other jurisdictions. For example, if you had, not you, but anybody had a warrant for, and they set a bail amount of $5,000 and it's from some county far in Northern California, the likelihood that they're going to spend the money to come down and pick up somebody in custody is very low. So Captain Labrada, who's probably dealt with the situation many more times than I have.
Most of the circumstances are involving misdemeanor warrants from outside the county, and in some cases outside the state. But very, very rarely will they come and extradite. And like Mr. Alicon has said, I've yet to see one involving an ICE warrant where we had to do that.
Well, I just agree with my colleague. I think we need to get as much information out as possible, repeatedly, just to continuously inform citizens and others what the laws are, what the rules are, and what the terms of engagement are going to be. So, thank you.
Thank you.
So look, my colleague has been very patient with us, but has to leave, Mr. Rue. And so what I want to do is receive and file the public report.
Councilmember? Oh,
yes.
I thought he was. Okay.
Thank you. I want to receive and file. Yes, sir.
Recommendations to note and file, receive and file the report, and we'll move forward.
Yes.
Okay.
And then move the closed session to the full city council.
Okay.
Too important a discussion for just the chair and Mr. Price. As much as we appreciate it, I think I think this needs to be fully communicated to the entire council for them to appreciate for their work in the city.
Mr. Chairman, just for clarification, the moving both the city attorney report in open session and the closed session item to full council, I think would be, because it would be easier to have, it would be more cohesive to have them together.
Yes, sir.
Okay.
So the closed session part will be at council at the soonest date we can get on the agenda. Okay. Okay. Good. Mr. Clerk, is that clear the file?
We have no further cards, no other items on the agenda, sir.
Okay, that clears the agenda. I thank everybody for being here this afternoon. Mr. Rue, thank you for your patience, and that adjourns this meeting this afternoon. Thank you, everybody, for being here.